proceed on counts 1, the felony 1 attempted murder with the RVO spec, count 4, felony 2 felonious assault with the RVO spec, and count 6, felony 1 aggravated robbery with the RVO spec.
Thank you. Before I ask you anything further, do you care to be heard on the matter of merger?
No, thank you, Your Honor.
All right, well, the court, we just discussed this in chambers. I had looked at this, and I was going to find counts 1, 2, and 3 merge, 4 and 5 merge, and 6, 7, and 8 merge, and the state has just indicated which counts of those they elect to proceed on. So we will proceed then. Counts 2 and 3 will merge with count 1. Count 5 will merge with count 4. And counts 7 and 8 will merge with count 6. So the defendant will be sentenced on counts 1, 4, and 6. With that matter addressed, Mr. Patika, is there any reason we should not go forward with sentencing?
No, Your Honor.
Is there anything you want to say on behalf of your client?
Your Honor, you know, at this point, you've heard all the evidence throughout the course of a very difficult trial. Mr. Flitcraft is 44 years old. He was doing some things right at this point in his life when this happened. He was working, trying to put things back together again. He has a supportive family. He has family in the back of the courtroom. We'd ask the court to consider, and we understand we're facing mandatory prison sentences here. We'd respectfully request the court consider concurrent time here. I believe that Mr. Flitcraft's niece would like to be heard on the record as well.
Well, we could hear from her and whoever else would like to speak on behalf of Mr. Flitcraft at this time. Whoever it is that would like to speak, you can just stand right where it is that you're seated, state your full name for the record so it's clear who is speaking, and spell your last name for our court reporter, please.
Hi, my name is Barbara Reese McCray.
Can you spell Reese and McCray for us?
Reese, R-E-E-S, McCray, M-C-C-R-A-Y.
Thank you.
And I'm Steve's cousin, older cousin. We're together as siblings, so I know him very well. Cousin is a loving, caring person who always puts his family first. He's been patient and attentive with my children. My husband and I, if he was here with my children, we said we wouldn't trust anyone else with them. They're 2, 3, and 6. And he's very gentle. Like I said, with his children. And he's very protective of his family. He really does. He's very helpful. He's the first one to volunteer to help us in any situation. He never puts himself first. He's a talented artist and he takes interest in training dogs. He is a productive member of society. If given a chance, if he can, instead of just being incarcerated, if he guide him, support him. He didn't have his father. His father was alcoholic and then was absent in his life. And he was doing very well when he was home. And I know in my heart, I know for a fact. I don't know if he's done this or not, but he's not a bad person. He is not a person that cannot be rehabilitated. He has good in him, a lot of good in him, Sorry, I'm very nervous, and I just want you to know that I trust Steve. I don't be a productive member of society if he's given a chance. It was unfortunate that he was institutionalized at such a young age, as a teenager. And then again, he did make another mistake and was incarcerated again. He's been incarcerated most of his life. And it would have been more beneficial to him to have, instead of just being thrown in prison, to be given, I'm sorry, I don't know.
Take your time.
have much of a chance. He's young, he's getting the maximum sentence, didn't hurt anyone, and now again, I'm not sure if he's being called guilty, but now he's going to be sent away. He's not able to experience, he's not been able to experience life and freedom, and if freedom is going to be taken away again, I just ask that he can, this last time he was incarcerated, he's got this head injury, that he has epilepsy now, and, our family needs him. We don't have a big family, and, my kids miss him so much. They only got to meet him for a few months, and, I'm just asking that he can be given some type of peace where he's not just thrown away to, be even influenced worse, some type of peace in his life, instead of just incarceration. Please, just know that he is a good person, that I know that he was not just simply, hurt people purposefully. He's not that person. He needs guidance, he needs support, he needs a chance to have peace. And that's what I want to say. I love my cousin very much, and I know he can be a productive part of this society. Wherever he goes, if he has to do more time, can it please be somewhere where he can not be just thrown in with, I'm sorry, I don't know. I just want peace for him where he can be an artist, maybe work with animals, have some type of contact with nature and outside, and have some type of quality to his life, because he was not given a chance. And that's what I would like to say. Thank you for your time, Your Honor. I love you, Steve. And
Thank you.
Everyone.
Mr. Tika?
Thank you, Your Honor.
Mr. Flitcraft, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
No, thanks.
Mr. Tika, anything else on behalf of the defense?
No, thank you, Your Honor.
Mr. Downey, on behalf of the State of Ohio.
Thank you, Your Honor. Your Honor is well aware of all the details of this case after having sat through an almost week-long trial, hearing from 20-plus witnesses, 200-plus exhibits. So I don't need to go into all the details of all that. I think that what was presented at trial pretty well lays out what happened. Just some notes, though, from the testimony and the evidence that was presented that I think are significant. We still don't know exactly what caused this to happen, because at the end of the day, no matter how many witnesses come in, no matter how much physical evidence there is, the reality is that there were 3 people in this car, and the victim, the defendant's sister, the other victim, and 2 of the people claim to not know what happened. But what we can kind of get from this is that whatever happened in that car that night appears to have stemmed from, at most, a simple argument. And the fact that the defendant then escalated whatever that simple argument was into an attempted murder is very, very scary. The photographs, the injuries, the testimony demonstrate that this was a very violent attack. And I think of note that is significant is the testimony and the evidence clearly show that after this attack happened on the road and Mr. Spooner drove to Garden Road where he went to essentially go die, in the driveway of 1192 Garden Road, the defendant comes back and passes him as he's bleeding out and dying there, grabs his bike, and takes off. And the fact that the police found Mr. Spooner is of pure luck. Really, they shouldn't have found him. What was apparent to all the first responders, the police officers, the paramedics, even the detectives, when they found Mr. Spooner, was that he was going to die. This was a murder. So much so that detectives testified that they rushed to the hospital to try to make contact with Mr. Spooner before he was life-flighted to get a dying declaration from him, because this was going to be a murder case. Now, through some miracle or blessing, it wasn't. Somehow, Mr. Spooner pulled through, despite the multiple injuries he had, despite the 7 blood transfusions, despite the multiple days he spent in the hospital and the injuries that he continues to suffer from today. He pulls through. But that is of no credit to the defendant. He did nothing, not only did he start this, but he did nothing to help Mr. Spooner or anything like that. So really, this is a murder case where somehow the victim, through the grace of God or whatever, pulls through. I think this is a situation where we easily could be talking about a life sentence. Now, obviously, that's not the case here, and we can't do that, but I think I say that to add the gravity to the situation here. This is not just some simple assault. Through the defendant's history the last 2 years, or the last 2 cases he's had, so in 1998, he pled guilty to a felony 2 felonious assault with a firearm spec. That was actually an attempted murder case that was dismissed. And a felony 2 conspiracy to aggravated robbery with a felonious assault spec.
And the case wasn't dismissed, that count was dismissed.
I'm sorry, yes, that count was dismissed, and he pled to a lower count. He received 8 years for that, and in that case, it was, he pled guilty to shooting somebody.
When did he get out on that case? Do you have that date?
I don't have the exact date, Your Honor. I do know that in 1998, when he was sentenced to the 8 years, he had almost a year of prison, or a year of jail time credit. So,
Okay.
8 plus 1997, through my calculations, he'd get out sometime around 2005-ish.
Okay.
He does get out. And in 2007, he pleads guilty to F1 aggravated robbery, another robbery count with a firearm spec, and an RVO spec, and a felony 3 having weapons under disability. In that case, he robbed a business with a firearm. And so he gets 15 years for that. He gets out in May of 2022. He's put on mandatory post-release control, and he only makes it about 5 months, because this incident happens on October 29th of 2022. So not only has he been given chances in the past before, but he's under supervision, and he still did this. You know, honestly, I think this is a really sad situation in the fact that the defendant's actions over the past 26 or so years have completely upended the lives of almost everybody close to him that he's come in contact with. The victims of his crimes, his family who has to deal with this, and society as a whole. But we can only go off of what we know, the facts of these cases and what his convictions are, and simply the defendant's history and actions in the past, and in this case, have demonstrated that he is just simply unable to exist in normal society. The defendant is the type of person that we all fear from. And because of that, he simply cannot be allowed to exist among us. I can't predict the future, but I would argue that we are about as close to as certain as we can be that if the defendant were to be allowed to exist in society again, he's going to seriously harm or kill somebody. Because it's happened almost twice in the past, and every single time he's committed an offense, there's been a serious robbery attached to it. So because of that, I think a significant sentence is warranted in this case to make sure that society is safe and to punish the defendant for what he did here. So the state is asking for a sentence of 45 years in this case. That would require some maximum sentences here, also to be run consecutive, which I think is certainly warranted in this case. I think that the discretionary RVO in this case should be applied. I don't believe that any of the findings are difficult for this court to find and are clearly and easily met in this case. PRC is mandatory in this case for 5 years, and I'd also ask that the additional PRC time the defendant has remaining, the 1,629 days, is also imposed in this case. And I believe that is well warranted, and I believe that's what's necessary to protect all of us in society from what the defendant may or will do again. Thank you.
Thank you.
Your Honor, the witness has decided he would like to state it.
Okay. I did receive your victim impact statement and have read that, but you're certainly welcome to speak here in court.
He pretty much nailed on the head. He's had plenty of chance to be rehabbed, and it's not going to work. You know, I haven't seen you. She said, hey, you know, all about family, and I never seen you over Cindy's house. I never seen you with him. So, you know, I just want him to go away for a long time, so this doesn't happen to somebody else, because, and I've been through enough, and I don't want to give him any satisfaction to know anything.
Thank you, sir. Thank you. Well, this court has considered the facts and circumstances of the offenses that are involved here. Obviously, I'm very familiar with the facts as they presided over the trial and had the opportunity to hear them all. So I've taken that into consideration. The nature of the offenses involved as well. I've taken into consideration what's been said here in open court by Mr. Katika, defendant's cousin who spoke on his behalf, the prosecutor's comments and recommendation. The defendant was afforded an opportunity to address the court, chose not to make a statement, which is fine. He's not required to, and he has the right not to. But I want the record clear that he was afforded that opportunity. I've taken into consideration the written victim impact statement that the court received prior to today's hearing. The victim was also present and addressed the court, and I've considered what he's had to say here in open court. I've taken into consideration the history of the defendant. All of this is being considered by the court in light of the purposes and principles of felony sentencing, which are set forth in 2911 of the revised code. As for the factors in 2912, factors indicating the conduct is more or less serious, the court notes that the victim in this case suffered serious, very serious physical harm. Quite frankly, he suffered economic harm as well as a result of not basically being out of commission for the last year. But in regards to serious physical harm, doesn't really get more serious than what occurred here. His relationship with the victim also facilitated the offense. And we are here in count one on an attempted murder, but as alluded to, and the court made some notes of this as well, the conduct engaged in by the defendant basically constituted the offense of murder. Now, he's not being sentenced for murder. He wasn't convicted of murder. But attempted murder means he engaged in conduct if successful will result in the commission of that offense. That means he had the requisite mens rea, the requisite intent to kill the defendant, to kill the victim, sorry. And the jury found that he purposely intended to kill the defendant, the victim, sorry. So he had that requisite intent, and quite frankly, the conduct he engaged in was more than sufficient to constitute the offense of murder. And the only reason we're not here for murder is because of the, who knows for sure, but the strength and desire of the victim to live and survive and fight. But it's not because of anything that the defendant did or didn't do to prevent the victim from dying. The conduct he engaged in and stabbing him, I think 13 times, was more than sufficient to accomplish what he intended to accomplish. And he, in a sense, is being rewarded for the victim's strength in fighting to survive, rewarded in not having a life sentence because it should be murder. And I'm not treating this as a murder case because it's not a murder case. The point in bringing this out in regards to the seriousness factors is that the conduct he engaged in was more than sufficient to result in the offense of murder. Most attempted murders we have is because somebody maybe shot at somebody and missed, but they had the intent to kill them, and that's why it's an attempt, or they maybe did something once or twice in an attempt to kill the person. Here he stabbed him 13 times, and the location of the stab wounds clearly shows his intent as well. So the conduct engaged in by the defendant in regards to count one here is much more serious than the conduct that normally constitutes this offense. There are no factors at all indicating the conduct is less serious than normal. As for recidivism factors, all of these are present. The defendant committed these offenses while he was on post-release control. He had been on post-release control for just, I think, 5.5 months after serving 15 years in prison. He'd been on post-release control for just 5.5 months and committed the offense. He has a history of criminal convictions. It may not be considered a lengthy history. It's just because of the nature of the offenses that the defendant committed. He has spent, by my calculations, 23 years of the last 25 years incarcerated because of the prior convictions he has from the 2 prior incidents. Most people we have to come in before the court have maybe a lengthy record. When we say lengthy, it's numbers of convictions, but they're misdemeanor offenses, F5 charges, possession charges. This defendant, in the 3 times he's now been before the court, had the most serious offenses you could have. In 1998, when he was just, I think, right around becoming an adult, convicted of felonious assault with a firearm specification, conspiracy to commit aggravated robbery with firearm specification. He's charged with attempted murder at that time. I don't know why, but I'm assuming because of his youth at the time, he only received 8 years in prison for that conduct. He got out, and within a short period of time, that happened January 15th of 98, he got 8 years, so he had to get out somewhere around the beginning of 2006. A year later, in February of 07, he commits another violent offense, aggravated robbery with an RVO spec and a firearm spec. Gets 15 years in prison. Gets out, within 5 months, he's now committing attempted murder and aggravated robbery and felonious assault. So the nature of these offenses and his history are extremely violent, extremely dangerous. He's obviously not responded favorably to previously imposed sanctions. There's no genuine remorse. The court finds that all 3 of these counts are subject to a mandatory prison term, as they are F1s or F2s, and the defendant has prior conviction for F1, F2s, which makes the prison term that has to be imposed mandatory for all 3 counts. Prison is consistent with the purposes and principles of sentencing. The defendant is not amenable to any available community control sanctions. Therefore, it is a sentence to this court that in count 1, defendant serve a mandatory indefinite prison term of a minimum of 11 years, maximum of 16.5 years. The court also finds that this prison term is inadequate to punish the offender and protect the public from future crime, because the recidivism factors indicating a greater likelihood of recidivism outweigh the applicable factors indicating a lesser likelihood of recidivism. There's no question if the defendant's out in the community, he's going to commit more violent crimes. That's what his pattern has been. That's what he's done. The court also finds that the prison term I just imposed in count 1 is demeaning to the seriousness of the offense, because one or more of the factors indicating the conduct is more serious than normal is present and outweigh the applicable factors which are on, indicating the conduct is less serious than normal for conduct that constitutes this offense. As a result, the court is going to impose an additional term in prison of 10 years for the repeat violent offender specification to be consecutive to the sentence imposed in count 1, 11 to 16 and a half years. On count 2, it's a sentence to this court, defendant serve a term in prison of 7 years. On count 3, the sentence to this court, defendant serve a term in prison of 8 years. Those sentences will all be served consecutive to each other. Further, pursuant to 2929.141, the court hereby terminates the defendant's period of post-release control and imposes an additional prison term of 4 years for committing these new felonies while on post-release control. That 4-year term is to be served consecutive to the prison term just imposed by the court for counts 1, 4, and 6. And I may have stated the wrong count numbers when I did that, so let me repeat myself. Count 1 was accurate. The 7-year prison term is for count 4, charge of felonious assault involving Cynthia Flitcraft. The term of 8 years is for count 6, the charge of aggravated robbery. I think I'd say count 2 and 3 unintentionally. So all those years with the 4 years for the post-release control results in an overall prison term of 40 years. He has credit for 370 days he's already served. Finds that consecutive service is necessary to protect the public from future crime and to punish the offender. It's not disproportionate to the seriousness of his conduct and the danger he poses to the public. And these offenses were committed while the defendant was on post-release control. And the offender's history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public, that's for certain, from future crime from the defendant. Further need to advise you, Mr. Flitcraft, that in regards to the indefinite prison term imposed, the definite sentences will be served first, including the 4 years for the parole violation. After you've completed the definite terms, you'll begin serving the indefinite sentence of 11 to 16 and a half years. There is a rebuttable presumption that you will be released from serving that indefinite sentence, again, after you've served the definite terms in counts 4 and 6, along with the PRC violation. There's a rebuttable presumption you'll be released from prison after you've served the minimum 11-year term. However, that is rebuttable, and when I say it's rebuttable, the Department of Rehabilitation and Correction may rebut that you being released at the expiration of the minimum sentence if, while you are in prison, you commit basically institutional rule violations or infractions. If they make determination that your conduct while you were confined, your rehabilitation, your threat to society, if any of that causes them concern and because of your conduct in prison, then you will not be released. You'll have a hearing. You'll be entitled to have a hearing. If after that hearing they determine that you have committed these violations while in prison, they do not have to release you. They'll give you a new release date at that point. That new release date will become the day that it's presumed that you'll be released. Again, there will be a presumption that you'll be released on that new release date unless, again, at a hearing, if the Department of Rehabilitation and Correction establishes that you, again, continue to commit rule violations and infractions, you're not rehabilitated, that you're a threat to the community, they can keep you in there. You will be released at the expiration of the maximum sentence of 16 and a half years, even if you misbehave the whole time you're in there. They can't keep you beyond that. Again, this is after you've served the definite terms for the other counts. I further need to advise you that you have a right to appeal the convictions in this case, as well as the sentence imposed. Specifically, if you are unable to pay for the cost of an appeal, you have the right to appeal without payment. If you're unable to obtain an attorney or counsel for your appeal, counsel will be appointed for you free of cost. That if you're unable to pay the cost for the documents necessary for your appeal, which would include a transcript of all hearings that occurred here in court, these documents and transcripts will be provided for you free of cost. And that you have a right to have a notice of appeal timely filed on your behalf. Now, Mr. Fatika, what is it, if you know, or I can ask Mr. Flitcraft, in your intention to appeal, is the public defender going to continue that representation, or is there a need to have a new attorney appointed?
Your Honor, we respectfully request that a new attorney be appointed for the appellate process.
All right, well, then the court will appoint new counsel for the appellate process. I will ask that you just monitor and make sure that a notice of appeal, if it's not done by that time, that you protect his rights, obviously, in that regard, but a new lawyer will be appointed for that purpose.
Thank you, Your Honor.
I also need to advise you, Mr. Flitcraft, upon your release from prison, you will be placed on post-release control for a period of 5 years. It's mandatory in this case. While on post-release control, if you violate any of the conditions of your supervision, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each separate violation you commit, up to an overall maximum of 50% or half of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as a part of the sentence at this time. Defendant's orders of penal cost incurred in this action. I don't know if it's required, but in regards to count one, I'll make the finding that this, and I've alluded to it, so I'm not going to repeat my comments, but this is the worst form of the offense for attempted murder, and I don't see how it can get any worse than stabbing someone 13 times with the intention to kill them. So I make that finding as well.
Does the defendant need to be advised of his enrollment in the violent offender database? Count one would be eligible for that.
Well, that will happen. Defendant will be entered into the violent offender database based on the conviction and conduct involved for count one. Is there anything else, Mr. Downey, on behalf of the state?
As far as the database goes, I think that there's got to be a form that's read, but that's the only other thing. Looking under 2903-42, Section C.
2903-41, you said?
42.
2.
It's a form from the AG's office.
All right, Mr. Flitcraft, I need to advise you, if you have been convicted or pled guilty to a qualifying violent offender offense, sentenced to a prison term, you will be required to enroll in the database personally with the sheriff here in Lake County. That's where you're going to be reside, or whichever county it is that you're going to reside, within 10 days after you're released from incarceration. You'll be required to provide the sheriff with the following information: your full name and any alias that you use, your residence address, your social security number, any driver's license number, CDL number that you may have, or state identification card number that's issued to you, information regarding the offense of which you are convicted or pled guilty, the name and address of any place where you are employed, the name and address of any school or institution of higher education that you attend, the license plate number of every vehicle you own or operated by you or registered in your name, the VIN number of each of those vehicles, and the description of each of those vehicles. You'll also be required to provide a description of any scars, tattoos, or other distinguishing marks on your person. You'll be required to provide the sheriff fingerprints and palm prints. They will also obtain a photograph of you at that time. After the date of your initial enrollment, you'll be required to re-enroll annually. You must update or amend any of the information described above that has changed and provide any additional information requested at the county sheriff's office within 10 days of the anniversary of the calendar date of which you initially enrolled. If you change your residence address during the 10-year enrollment period, you must provide written notice of that change to the sheriff most recently enrolled and to the sheriff in the county in which you intend to reside within 3 business days of the change of address. You are required to comply with these requirements for a period of 10 years unless this court determines otherwise, that it would be less. Again, you'll be required to register, enroll with the county sheriff in the county that you will be residing within 10 days after the release from incarceration. Your failure to enroll or verify your residence at the specified time will result in additional criminal prosecution. Let me put some additional information here real quick. What's this case number? Do you have that, Adam?
22 CR 1230.
Your middle name, Mr. Flitcroft?
Richard.
Thank you. I don't know if you know, do you have an expected residence address where you'll be residing when you're released at this point, or not? I'll just say unknown at this point. Flitcroft, do you have any questions about these requirements you'll have to enroll upon your release?
No.
I'm going to print out this form here so you can have a copy. I'm going to have you sign it, which simply acknowledges that I read it to you and you understand that you're not admitting anything or in that regard, just acknowledging that I read it to you. And you understand it. Revised code violations are 290302 and 292302, correct?
Yes.
For count one. I'm going to have the bailiff hand you this form. Rule line 10 reads, I acknowledge the above requirements have been explained to me and I understand them and then I must abide by them. Please enter your signature on line 10. Today's date is November 3rd. I will sign line 11, which indicates that I certify, specifically inform the defendant of his duties as set forth above and indicated to me an understanding of those duties. Shannon, if you could please make copies of this and give a copy to Mr. Flitcroft as well as the lawyer and the prosecutor.
This case shows how a simple argument turned into a near-fatal attack. The defendant stabbed the victim 13 times, then left him to die. With a violent criminal history and repeated chances waste, the court delivered a 40-year sentence to protect the public. This is why the judge called it one of the most serious cases he has ever seen.